Hey everybody, welcome. Thanks for joining us today. My name is Mike Gibb. I run accountsrecovery.net, and I'm excited to bring you today's webinar on understanding the debt collection rules provisions for texting and emailing. Now that the CFPB has come out and given debt collectors the green light to send text messages and emails, not that they didn't have the green light before, but now there's boundaries, I guess. It is doubly important for collectors to know the ins and outs of obtaining consent and what to do when it is revoked. Today in this webinar, which is being sponsored by TCN, we have a panel of compliance experts who are here to share their analysis for communicating via email and text messaging. Before introducing the panel, I did want to take a quick second and talk a little bit about accountsrecovery.net. Specifically, I'd like to spotlight a couple of ongoing video series, which I hope you'll check out. They're available for free on the site. Training Bites is a series of videos featuring insights from Mary Shores, one of the industry's leading communications experts. And You Wanted a Rule, You Got a Rule is a series featuring John Bedard, who is breaking down each section of the CFPB's debt collection rules. You'll find both series in the video section on accountsrecovery.net. As I mentioned, this webinar is being generously sponsored by TCN. You'll get the chance to hear more about them a little later in our program. Now, let me tell you a little bit about today's speakers. Tim Collins is the Chief Customer Officer at Indebted and a 20-year veteran of the ARM industry. He has served as General Counsel and Chief Compliance Officer for multiple industry-leading organizations and remains actively involved in ACA International. He is a well-known industry thought leader and innovator. Joseph Messer is a partner with the Messer Strickler law firm, which concentrates in defending collection agencies, debt buyers, lending institutions, and credit reporting agencies, and others in consumer lawsuits brought under state and federal consumer protection laws. Joe is nationally recognized in the area of consumer litigation defense at the trial and appellate levels. He has been lead counsel in many class action lawsuits brought under various state and federal consumer laws, including the FDCPA, FCRA, and TCPA. Unfortunately, both Chris Meyer and Judd Peak are not going to be able to participate today because of the severe weather they're going through in Texas and Tennessee. Hope they get through okay. The format for today's webinar is going to be a panel discussion. We encourage everybody to submit questions, and we'll get to them as the discussion is ongoing. To submit a question, please either enter it into the Q&A tab or the chat module on your Zoom webinar control panel. Since we're going to be talking a little bit about compliance today, let me read the following disclaimer. This presentation is not intended to be legal advice and may not be used as legal advice. Legal advice must be tailored to the specific circumstances of each case. Every effort has been made to ensure this information is up to date. It is not intended to be a full and exhaustive explanation of the law in any area. It should never be used to replace the advice of your own legal counsel. Almost got that completely memorized. That's close without having to check my notes. All right, Joe, Tim, thank you very much for joining me today. We're talking about something that is at the forefront of a lot of minds and a lot of conversations going on in collection operations across the country. And that is how to text and how to email. So first, I thought we'd start by asking, let's start by looking at the limits on call frequency, which is something that the CFPB put out in its debt collection rule, and ask that. I don't think it applies to email, but I will ask how the call frequency limits apply to text messaging and email, if at all. And Tim, we'll let you kick us off today.
Thanks, Mike. Great to be here with Joe. Thank you, TCN, for sponsoring us today, and Mike for pulling these together. These are always great sessions. I'm always honored to be a part of it. If we look at the rule, we knew call caps were coming, call restrictions, and so the CFPB did a great job on laying out what that is and where it applies, and it applies to calls. We don't see anything as it relates to email in that piece. But I think if we take a step back, really what the CFPB was trying to do with the new rule is really to get agencies, debt buyers, everybody focused on the consumer like they are. Their charter is to protect consumers, and that's what their whole focus is on. So I would say that they're giving us guidelines on calls, but we need to be able to apply those and really be consumer focused through our whole process, whether we're text messaging. Nobody's sending 7 letters a day. I hope not. They're not in business long. But text messaging, emails, phone calls, all that stuff needs to be taken into consideration as you're going through it. I kick it over to Joe to get his thoughts on, how call caps apply and where he thinks it's going.
Yeah, thanks, Tim, and thank you for having us, Mike. This is an honor to be presenting in front of everybody here today. First of all, just to remind everybody, this rule is not in effect yet. It doesn't become effective until November 30th of this year. So what we're talking about here when we're talking about the rule is, something you have to wait for to be able to utilize.
You didn't cross your fingers.
Right. That's a good point. I mean, I'm hoping that nothing changes. But anyway, regarding frequency of calls or texts, I should say, and emails, yeah, the rule doesn't have any specific limits, but there are other sections of the rule and the FDCP in general that would arguably prohibit repetitive text, certainly repetitive text messages. Emails maybe less so because those are more passive. You don't have to look at them until you open up your email. But I mean, the rule itself, section 1006.14a says, just like the FDCPA, that debt collectors are prohibited from engaging in conduct, the natural consequences of which is to harass, suppress, or abuse any person in connection with the collection of a debt. So if you are texting a person repeatedly, I think you're arguably violating that rule. Possibly, if you constantly are emailing somebody, you'd be violating that rule. So I think that probably the best practice is to kind of treat it like you would letters, right, or calls. Don't send constant emails and letters, just like and text, just like you wouldn't make constant calls or send constant letters.
Yeah, that's a great point, Joe. I mean, everybody's so focused on the new rule that's coming out, and how do we get clients to give us the data that we need, and how do we prepare for it? And really, we have to remember the fundamentals that are out there, right? And harassing conduct, misleading conduct, all of those things. That's where the litigation's happening right now. That's what you're seeing, on a daily basis and defending. This just gives us potentially other channels for plaintiffs' lawyers to make that argument that's exactly what we're doing. I could see scenarios, where you could have, tried your 3 attempts, in a day. Then you've got a couple of text messages that are going out also to try to get some follow-up, and then maybe, 2 or 3 emails. And next thing you know, you've got all these contact attempts being made. And, a judge sitting on the bench somewhere saying, that seems like a lot. Would I want that? And I think it's something definitely to be keeping in mind.
Yeah, that's a good point. I hadn't thought of it in that context where you're adding up the different types of ways to communicate, right? So you could calls, letters, emails, texts, right? So you should think about that. You should think about, okay, well, I called this guy today, so should I text him today and email him today, or is that going to be considered to be like 3 attempts to call? Because you see these cases where, and it's always the facts, facts make bad law, or whatever. You see these cases where the recitation of the facts are that the collector tried to contact a person 58 times in 1 month or something like that. Well, when you just have letters and calls, that's a lot, but maybe it's not so much when you have letters, calls, texts, and emails. So now all of a sudden, that 58 number, which seems on its face to be excessive, is a lot easier to get to than it used to be. So I think that's something to keep in mind in a collection campaign.
Any idea why the CFPB didn't kind of sort of lump all those communications together and instead just chose to sort of focus on phone calls in and of themselves?
That's a good question. There are a lot of things that they didn't do, and I don't want to be a complainer, because it's like John Bedard said, you wanted a rule, you got a rule, right? But I will say that there are lots of areas where they kind of just left questions unanswered, and I can't tell you why they would have done that.
Okay.
Yep. I think Mike, if I may just touch on that a little bit, not trying to step into the shoes of the CFPB, but I think when they look about the Telephone Consumer Protection Act, right, and sending out text messages, there's always that potential the consumer can say stop pretty easily. You have to stop. There's a big hammer there if you don't. $500 for the first, all the way up to $1,500. It can be very, very expensive, very, very quickly. So they might have taken that into consideration as part of it, and we've got that. From an email perspective, email is less intrusive. So if we think about phone calls being probably the most intrusive, you have to answer it now if you want to engage, right? And then you've got text messaging, which is it's more real time, but not as urgent as a phone call. And then you've got email down below, like Joe was talking about, very even less intrusive. So if that might, from that perspective, they said, this, because it's less intrusive email, you can see it at whenever you want. Maybe it doesn't necessarily pop up. Some people have it pop up on their phone. I don't. You just get too many emails there. It's just, it becomes crazy. But there's also those other restrictions like email deliverability. You send a lot of emails to one consumer and they mark it as spam. They ask to be opt out, all these things. So there's other controls, market controls that are actually in place. And I think even the TCPA has a chilling effect on the market to be able to send text messages. And we're now seeing with, obviously, everybody's been talking about the T-Mobile decision to come out and block debt collection calls. So I think some of those other things were potentially in play when they were looking to come out with this rule. I think one of the other things is too, if you look as an industry, still the majority of communication with consumers is over the phone, mainly outbound phone calls. Mm-hmm. So I think if anything, maybe that was, part of, they wanted to handle that piece first, let these other things. Yeah. And so let the market run those other things. So, but those are just, speculations on my part. Sure. But I'm glad that we've got some of that flexibility. I'm glad we've got, the ability to send emails when we need to be able to send emails, find out what that right number is. And again, to me, it comes back to being that customer focused, consumer focused. So
excellent. I'm just going to break in here for 1 second. We're just going to pause our discussion and say a few words about TCN, the sponsor of today's webinar. TCN provides cost-effective call center solutions for traditional contact centers, collection agencies, and thousands of businesses worldwide. TCN has continually stayed current with TCPA and CFPB changes by introducing enhancements to its core platform, one of which is TCN's natural language compliance, which uses smart algorithms to build compliance rules naturally. Simply type your rule into the TCN Compliance Manager, and the natural language compliance engine will build an easy-to-understand compliance rule. One example of a rule could be deny outbound calls before 8 a.m. and after 9 p.m. You could even type a rule that would limit 7 calls in 7 days. There's no limit to the number of rules TCN's processing engine can compute. TCN software is a platform suite that also provides built-in data management services that eliminate data entry errors, business intelligence with reporting dashboards, call recording with storage, smart IVR with payment capabilities, speech analysis and transcription, and much more. Regardless of size, location, or application, TCN can provide a robust solution for your call center and collection agency. Give TCN a call today or visit them at www.tcn.com for more information. And I put a link in the chat box to anybody who needs it. I'll put it in there again in a few minutes. Thanks again to TCN for sponsoring today's webinar. All right, questions from the audience are starting to come in. So I'll use this as an opportunity to remind everybody, if you have a question for Tim or Joe, send it to us through the chat module or through the Q&A, and we'll do our best to get it asked and answered during our conversation today. First question, come November 30th, do you think we should treat SMS, if it's delivered, no more than 1 every 7 days, just like calls?
Joe, I'm going to defer to you because
well, I think the question is, does a delivered text message should be treated the same as a conversation?
Right. I think that's a good question. I think if you go back and read the letter of the law, assuming we're now November 30th and it's in effect, it applies to calls specifically. And so I think you could say legally, we're allowed 7 attempts in a week. There's a cool off period. There's all those things. You follow the rule, and it's very specific about calls. If I could reframe the question just a little bit and kick it over to you, Joe, do you think, based upon your experience with some of the most outstanding plaintiffs lawyers out there, that you will see an argument made that said, hey, look at, you made, 7 phone calls, but you also did 3 text messages. We think you violate the rule.
Yeah, and I'm glad you put that. You rephrase it that way, because it, I hate having to tell people that they can't do something that the law specifically indicates that they can, right? So as you said, Tim, I mean, there is not this, the limitations pertain to calls, not the text communications. So I think that the black and white answer to that is based on what we've read in the statute, what the rule says and the statutes say, and all that, you're okay. That being said, what are the creative plaintiffs' attorneys going to do? They're going to do exactly what you just said, Tim, or you should be at least prepared for them to do those things. And, that means that that you're taking it, if you want to communicate, if you want to treat it as not a call, so it's not being counted as a call, you can do that, but you're taking a risk that somebody's going to argue that the same counting mechanism should apply, should be treated like a call. That's going to need to be litigated, and it will be eventually litigated. I can almost guarantee you. And so it's important to watch that and see what the courts are saying about that. Do you want to be the guinea pig? That's up to you. Do you want to stand down and wait to see what other collectors do and how the courts come out on that? That's, another approach to take to that problem.
Correct me if I'm wrong, and I'm sure you either of you will, but I mean, under the TCPA, hasn't there been legal rulings that say the text message is equivalent to a call?
Well, that's the problem. And now we've got this overlay of one of the problems. We've got this overlay of the rule now. So does the rule disabuse that notion? Because we have specific rules that don't that characterize calls differently than text messages. That's how I'd argue it. I'd say, well, no, a text message is no longer akin to a call. It's its own animal, because we've got a rule that talks about that. But of course, the plaintiffs will take the opposite position.
Yeah, I think to Joe's point, be right facts, right judge, get the right case law on here. But this is something that we should anticipate seeing. And again, I think it comes back down to, if you're doing 7 attempts and 7 text messages and 7 emails, all in the same day, same week, that's likely to drive a consumer to find some way to stop the calls or stop the text messages. And when they do those searches, what usually comes up is a plaintiff's lawyer's website, and they're just trying to find a solution to their pain, right? And so it's really saying, let's be smart about this. Let's be saying, okay, we're going to do phone calls. And I think today, with analytics that we can look at the data and say, well, here's what makes sense to be able to reach out to consumers. There's times where you kind of slow ramp the consumer up because they start to get familiar with you, build that relationship. Then you do a little bit, maybe a heavier communication, and there's a cool off period, and then maybe there's another round where you can ramp back up, but you're waiting for that consumer to engage. And that should really be that driving force. Joe has slacked me on the side and said he's going to brief this whole issue and have it provided to the people of the webinar today. So these are the kind of things that keep us lawyers up at night, right? Because we never dream of this stuff, but it's always in the back of the mind, and the plaintiffs' lawyers are very, very creative around it. So I think we've got another question in here. Joe, I'll just tee it up to you. Is there a timing issue as to when an email or text can or cannot be sent?
So yeah, that's interesting, because I was looking at the rule to prepare, and that popped into my head. but I do think it's the same rule. Well, certainly with respect to text, you can see why the time limitations, not before 8 a.m. and after 9 p.m. of the local time of the consumer, right? You can see how that would apply, that should logically apply to text communications. Because for the same reason, you shouldn't be calling a person in those off hours. You shouldn't be texting a person in the off hours. However, emails don't appear to the consumer until they open their email. And so should that rule apply? Does that rule apply? There's nothing that I see that says that rule does not apply, but is it really very meaningful with respect to emails? So it's probably another area that we're going to get some litigation, because somebody's going to send the email saying, well, I don't expect the guy's going to open his email until after 8 a.m. So I figured it was fine to send it. And then the plaintiff's counsel saying, no, why would you be sending, blast emails at midnight? Because, your system's sending these emails. And that could be a class situation, I can imagine. So I think probably the safer practice, sorry for the long answer, but I think the safer practice, unless I'm missing something on the rule, is to just abide by the same time limitations as exist with respect to telephone calls. What do you think, Tim?
Yeah, I agree, Richard. I think that, especially because we're using it for the first time, and so email is one of those things that's very much like a letter. We drop letters in the mailbox. We have the mailbox rule, right? But we don't know when that letter gets delivered or when that consumer opens it. So you can make the analogy, right, that email is really like a letter. It may be sitting on your nightstand and you open it up at midnight. That's clearly not outside. And I would make that argument that that's kind of how email should be treated. It's kind of like a letter. You get to open it whenever. I'm sure that there's a plaintiff lawyer out there could say, yeah, but it pops up on their screen, wakes them up in the middle of the night because they have their notification turned on. And so now it's like, oh yeah, that's a hard argument, to make. And we would counter with it and say, it's more like a letter. They could look at it at any time, and it's less intrusive. And it'd be great to get some case law on that. But ultimately, you're trying to get the information to the consumer so they can make a decision about what they want to do. And that's one of the things that's going to be our driving, that's a great defense to walk in. We want to make sure they got this information so that they could act upon it. But again, right facts, right judge. So.
Right.
If we talked a little bit about sort of the abusive, oppressive, harassing conduct, if we could transition a little bit to talk to a topic that Tim and I have had a number of conversations on over the years, and he loves talking about, and that is consent. The consent to send and receive text messages or emails, and the revocation of consent to send and receive. There are some very subjective terms in the rule, reasonable and simple, to name but one. Joe, maybe you could sort of walk us through how you would advise those watching and listening to sort of approach the consent portion of texting and sending emails.
Well, first, remember that the rules are different as between emails and texts.
Correct.
So that's the first thing to bear in mind. And you can't just lump them in together. You got to look at the rules with respect to each. And I would say read the rules. Definitely. I mean, they're not that. I mean, you're only talking about reading about 4 pages to understand what it says. But I mean, and I would also say go slow with this. And again, test the waters by dipping a toe in, not just jumping in. If you clearly have a consent from a consumer, and you can check all the boxes for the consent requirements in the simplest, most straightforward way to obtain consent, do that. But I would caution against the consent sections that allow you to rely on, say, for instance, the consent that was given to the creditor that you're going to inherit, or certainly the consent given by a prior given to a prior debt collector that you're going to try to rely on. I think those are problematic because you don't know for sure. Like, for instance, the rule on consents with given to prior debt collectors. It reads, if the immediate prior debt collector obtained the address under which the first two procedures, immediately prior to the debt collector used the email address to communicate with the consumer about the debt, the consumer did not opt out of such communications. So you need to know those things. You need to be certain that the immediately prior collector obtained the email address and that that consumer didn't opt out to that immediate prior debt collector. I don't know how you're going to know those things for certain. And when the litigation occurs and you're issuing subpoenas, that's not the time to figure that out. So I think you got to really be careful about that.
Yeah, and I would agree. I think if we take a step back and start at the clients, a lot of clients I talk to about, they got the terms and conditions allow you to send a text message, and I agree with Joe. We got to keep the email and text messaging separate. But if you follow up and ask them the simple question of, well, tell me what the revocation process is for you guys, and a lot of times they'll be like, what do you mean? That's a warning sign for me right away. It's like, okay, so is the word too big? Revocation, too many words, too many syllables? So how do you know the consumers don't want to be contacted that way? And if there's not data fields that are going back and forth, so if clients are saying, yes, we've captured consent, as an example, and they send you the phone number and you're the primary agency early out, whatever that is, you're the first one. No other agencies are working this. It'd be difficult for me to believe that there's somebody in that group that has not opted out of text messaging, has not typed in stop. Because if I don't have the ability to send that back, because when I start texting, I'm going to get data that says I don't want to receive a text. I need to be able to send that back to the client. So if you don't want to ask that question, just look in your system and says, is there a field we're sending back to our clients that says they've revoked? If not, then that's a clear warning sign as it relates to the TCPA and consent. Now layer on what Joe was talking about, right? Now you're in your secondary agency, maybe a tertiary or quad, and knowing, none of that information is getting passed back to the creditor because the accounts don't come from the other agency, right? That's not how it works in our space. They go back to the creditor. The creditor has either updated their information or not. Better creditors do, and debt buyers do, and then that information is placed out with another agency. So it's like when you sit around in a circle and you whisper somebody in somebody's ear. By the time it gets back around to you, you have no idea. And every time you add an agency in there, every time you add a human in there, who's taking a phone call, getting the text message if it's not an automated process, having consent captured on a website or revoked on a website, there's all these opportunities for you to lose that consent. So it really becomes down to now thresholds of risk. And there's ways that you can get around you still might want to be able to send text messages. So how can you capture that for your agency? That's what I think is extremely important. Joe, you have a point?
Yeah, well, I was thinking maybe the best way to look at it, again, just putting your toe in the water in this area, is certainly people, I mean, I prefer, I don't like text messages, but I prefer to communicate via email, right? So I'm sure many consumers feel that way. So if you invite, by sending, let's say, your initial validation letter, you invite a consumer to communicate with you via email, and they begin doing that, they've consented, and as long as they haven't withdrawn their consent, you're good to go under the rule. I mean, to me, that's the safest way to approach this thing, and maybe that's where you start rather than diving in. I think the second level of it is where you have a portal where somebody can start to communicate with you via electronically in that manner, and then you obviously need to have their consent you want to give them the disclosures and that type of thing through the portal. But to me, it's kind of like, as long as you've got a consumer coming to you saying, yeah, affirmatively, they are trying to communicate with you via email, then I think you're in much better ground, provided you check the other boxes of the rule. Texting is a little bit more difficult, I think, because I don't think as many consumers are going to text although maybe it does happen. I don't know, Tim, you can tell me, but it seems that consumers would be less likely to text a collection agency.
Yeah, it's surprising. We did some analysis at an agency I worked for a while ago where we turned on text messaging receipts for the 800 number. And we're just surprised by the number of consumers, because there's a generation that kind of grew up on text, kind of that Gen Y. And so they're used to that communication channel. I'm like you, Joe, I'm used to doing email. It's more business. It's more, it's a little bit more formal. There's text messaging now. And so you'll be surprised at the consumers that are actually willing to text you. And to your point, I think if a consumer reaches out and starts texting you, they want to engage with you via text. That would be consent for me. You sent me a text, and we're now engaging in that two-way communication. And I've seen there's an agency in Illinois that has actually a short code on the top of their website. It's the first thing you see when you're on a mobile device, and you can click on it, and it'll open up a text thing, and you could just text whatever you want, and then it starts to build that relationship with you via text. And so the more that you can remove friction from the process, make it easier for consumers to be able to text you. So you could put a long code on there, so text us at this long code, call us at this phone number, email us here. Even if it's just info@abcagency.com, start that communication piece, because now you can fall back on to that. As you were talking about, Joe, they're now engaging with us. Some plaintiff lawyer doesn't know that all those emails happened back and forth, or all those text messages happened back and forth, and you just show them no, this is the way they wanted to be communicated with. So,
that you made a good point, and I don't want people to take from this presentation that I'm telling you don't do this, don't communicate via email, and don't communicate via text because you're going to get sued. I don't feel that way. What I feel is that you got to really be reasonable about it. And one point, Tim, I think you made, is that people, like certain generation likes to communicate via text and email. Also, text and email takes out the confrontation. It can take out the confrontation. So you get a consumer they just don't feel comfortable talking to somebody on the phone about their debt, but they can put it in writing in an email. They're not going to sit down and write a letter and put the letter in the mail the old-fashioned way. They want to be able to do this, like people normally communicate now, which is via email. So certainly that's something that should be encouraged. I think it's going to help collections. I think it's especially helpful though if they reach out first and they're the first ones to send the email or the text.
Yeah, agreed. And however we can do it to make it easier for them to be able to do that piece. Couple of questions popped in about email communication. Like, where would you add that invitation to email communication on the new sample validation letter? And my response would be every place that I possibly could, so that they would engage with me, and I would send my validation letter via email. But Joe, I don't know if you have any additional thoughts on that.
No, clear, conspicuous, not buried, not on the back page and, in 3-point font, just make it, there's no reason to. I mean, you're wanting them to do it. So let's get it out there. It's almost like a service to them.
Exactly. That dovetails nicely into, are there tools out there to manage email opt-outs? Yes, really comes down to your email provider. So whoever's sending out emails for you should have that. It's part of the, especially if they're doing marketing emails. Debt collection is not marketing emails, but there are tools out there, and it's usually by your email provider. So just to be able to answer that question.
Usually it's just as simple as an unsubscribe link that you would put in your emails.
Yep, absolutely. And it's always been good practice to give consumers the ability to opt out of channels. We haven't necessarily done that because we've only had 2 channels, phone calls and letters. And if they opt out from the phone call, what are we going to do? We're not going to send them a ton of letters. But now we have these other channels. So the more channels we can communicate with them. It's amazing if somebody wants the calls to stop, and you put that on the website, there's a great way to prevent litigation, by the way. If you put in there, please stop calling this number, and then you ask for them, well, what channel do you want to be communicated with? Via email or would you prefer text messaging? About 80% of the consumers will put in an email address based upon my experience. They just want to be communicated with potentially the way that they've always communicated with about the account to begin with. They signed up online, they received email statements, they've communicated back and forth. Maybe there's a call or a web chat, any one of those things. And so giving the consumer the ability to say no to a channel, but yes to others is definitely something to be thinking about. So,
with respect to opting out of text messages, the rule says that the opt-out instructions have to be reasonable and simple. Would either of you like to take a crack at how you would define what reasonable and simple means?
Well, I can tell you one thing: you cannot charge for opting out. The rule is very specific about that. I can't imagine somebody doing that, but they put that in the rule. And they correlated it to the way they try to do it in the rules to correlate it to the way the notice of the right to opt out was given in the first place. So just think about the easiest way to respond. If you got something electronically, the easiest way to respond is not to have to write a letter to somebody, not to have to pick up the phone and call somebody. It's to click on a link, right? If you send a letter and the communication is the old-fashioned way through the mail, yeah, maybe you can require them to like fill out a form and put it in a self-addressed envelope and send it back to you. So it's correlated to what the method of giving the notice of the right to opt out is in the first place. Simpler the better, easier the better.
Yeah, but I would agree, because the last thing I want to do is be standing next to Joe.
Hey, come on now.
In front of a judge,
Okay.
right? No, I'll stand next to you in front of a judge going, yes, the only way you can stop text messaging is by sending a letter, right? You're clearly that's not allowed. It's as easy as the word stop. It could be something that may be equivalent to stop, maybe in a middle finger emoji might be a good indicator that you should stop texting. But to Joe's point, it's whatever the channel it is. I think that's easily more defendable than creating all these hoops. And we've been an industry that creates hoops that adds friction. That says, hey, if you want to contact us, it has to be this, these times during this, if we have somebody available, we're only going to contact you between the hours of 9 a.m. and 5 p.m. when we work. So it's again coming back to that, to really being consumer focused, and that's what you want to be able to. What would you expect from that experience if you want emails to stop? How would you expect to be able to do it? You should be able to click on a link, and then it should automatically, once you click on the link, send you something back that says, okay, you've been removed, or drops you on a website that says removed. I can't stand these ones where I got to know now type in my email address. They specifically are putting friction in to try to keep you on their email newsletter. And I'm not talking about you, Mike Gibb. But there's others out there, right?
I charge people to unsubscribe. I didn't know I couldn't do that.
Well, as long as you're not doing debt collection, but that's not legal advice. But my point is it's like, make it as simple for the consumer, because they don't want to communicate with you through that channel. Give them the opportunity to communicate with you in some other means, if that's what they choose to do. So,
well, what's the data say that there's? What do we think? What do we see? There's 13,000 different ways that a consumer can opt out of a text message now through, the whatever choice of words or phrases or emojis. So
yeah, you're right. TCP.ai has found, using machine learning, somewhere in the neighborhood of almost 13,500 Spanish and emojis. I would have thought there would have been one emoji, but there's more than one. So we're going to need to know that. Whether that's a cease and desist, that's probably a cease and desist. I think you can make an argument against stop.
That's how that's going to come up.
Yep, exactly. That's what you're going to see.
So a frown emoji, is that going to be a cease and desist?
Potentially. You're going to have to defend that, and so it's going to be, or a combination of emojis, or
Right.
what does that look like? You should have had the intent to believe that this is so. It's gonna be good for business, Joe. So I'm
Yeah.
very, very excited about text messaging and email. Unfortunately, so
Go ahead, Tim.
no, I think we've got a couple other questions teed up, and I want to make sure that we stay on topic and not dive too far down a rabbit hole.
No, that's fine. I wanted to take a few minutes and talk a little bit about the way the CFP built the rule. The CFPB built the rule was they put a lot of safe harbors into the rule for collectors who engage in some of the different provisions that are listed in the rule. So I wanted to ask how the safe harbors work as they pertain to email and text message communications. Is that something you want to take first, Joe or Tim?
Well, Robert put that question in here, and there's a great safe harbor in here where the creditor sends out an email to the consumer, and you wait 35 days. It's a third-party disclosure safe harbor,
Mm-hmm.
right? And it's nice that they put that piece in there. It gives the consumer 35 days basically to opt out, if they will, from or saying this is not the email that I want to be contacted at. And so I think 35 days is a long time. So I don't look at emails that are 3 days old because there's a stack above them, right? So it's very, very difficult to be able to go back. So I don't know how practical it's going to be. And I think email is one of those things, based upon my experience, it's still pretty personal. People keep it it's locked down for most. Google has, you have to have a password and stuff. So I'm not really sure. We haven't seen a lot of litigation around third-party disclosure via email. So it may be a safe harbor that's not really necessary. And it may not be practical to a creditor because you're basically going to be telling a creditor, hey, send out an email before telling them I'm coming. I think all creditors should do that. I think it helps with collection activity. It helps build the relationship with the agency. That individual might not be in the right position to take care of their obligation at that time. And so they're waiting for that agency because maybe they're now in tax season and it can help. And there's any number of circumstances. So, but overall, you have to look at those and say, okay, are we going to be willing to jump through all those hurdles? And in this case, to answer Robert's question, it's the creditor that has to be willing to do it, right? Send a letter, send an email, do something. And there's not a lot of investment yet. There's more coming in the post charge-off world, right? It's still, hey, your account's now in this new world, and there's not a lot of investment by banks in that space or creditors in that space. So I don't really see it being used. But it's something to ask your creditors. Maybe you have a smaller creditor, somebody along those lines. So hopefully that answers that question. But Joe, any thoughts that you have there?
I always look at things like what, from the standpoint of defending a case, and then part of the analysis is what information do I have what information does my client have? What documents? What paperwork? What texts do they have that's been captured in their system? All right, that's our little universe of information that we can use to defend the case. And usually, hopefully that's going to be pretty comprehensive. It's going to allow us to do what we need to do to defend the case. But now if I have to go to a third party to get the documents and the information I need to defend the case, all of a sudden now we're in a much more difficult situation. We've had a lot more work to do, and the case may or may not be as defendable. So to your point, Tim, when relying on somebody prior to you, your involvement in collecting the account, that you have to get that information from them. You have to get those documents from them. That's inherently problematic. So we want to have a system where if we're going to do that, if we're going to rely on that kind of thing to create a safe harbor, we have to have a seamless way to get that information. Those documents, that information has to be provided to the collector as part of the collection process. It can't be a situation where they tell you that they did something, and now you're sued on it. You have to go back and check with them to see if in fact they actually did do that. You have to be able to say, look at your own system. Their information has become part of your information. You can adopt it. You can say, oh yes, they've done that. Because now you're into a perfect bona fide error defense, right? You can say, look, we have a system to verify that this consent was given, that it wasn't revoked, or that the creditor told us and told the consumer that they were going to provide the email address. If we can do that, that's great. But if we're having to run around after the fact and try to prove it, that's not so great.
Great points. Staying on email topic, if that's okay, Mike. Mr. Kraft put out a question here about the rule says no. This is where we're going to need a good legal mind. So, Joe, this is where I'm grateful you're on the call. So, the rule says no, not no or should know when it comes to work emails. The mere fact that a email URL is something other than Gmail, Verizon, Comcast, etc., does that mean it's a work email or that it would be, lacking privacy? So, in the rule, they talk about an email that if you know it's a work email, that you can't send it to a work email. How do we know it's a work email address?
And that's an interesting, and I was looking again at the rule this morning, and it's, I think it says in the rule about that you can gain that knowledge from any person. I don't think it says like it has to be from the consumer or from a specific database or something like that. Is that, do you remember that, Tim? Is that how that reads?
Yeah, because there's really not technology out there. I mean, we could take a good educated guess, right? So we could say anything that ends in .gov, .gov, probably, but there's probably exceptions to that rule. Some could make the argument it's an edu, but I would say that's students. For some students, that's their only email address because they don't set up email addresses. They're texting and Snapchatting.
Sure.
So I don't think but again, I think this issue can be resolved by kind of what we were talking about earlier, Joe, where you give that consumer the ability to opt out easily, right? And maybe then it's ripe for, analytics, a database internally that says, hey, if you see this consumer again, you're not going to want to email them because they don't to this email address because it might not work. Now, I will say that there's companies out there like Experian, Newstar, TransUnion that can scrub email addresses. And so you could create some sort of process along those lines. The biggest concern I have about this rule and this restriction is for some consumers, potentially the only email they have, and this is why they used it to set up the account originally, was a work email address. And I know that's hard for some people to believe, but for some people, they don't have, a smartphone, or they don't have a data plan that allows them to do that piece, or they lack the sophistication in order to be able to do that. And now you've taken away the channel that they want to be able to communicate with. So my concern is when it comes to that is we shouldn't, if that's how you set up the account, that's what the original creditor has, to your point earlier, right? The original creditor has all that information. That's how they set up the account. That's what's on the application. That's that process. That should be the one that we use, right? Because they set it up. That's their expectation. Let's meet their expectations. I think there's a bit of a miss there with that rule. That would be the argument that I would go out with and say, and have all that, have all that documentation and all that backup. If we had to stand before a judge or ask a CFPB, respond to a CFPB examination saying, okay, why are you emailing work email addresses? Well, this is the email address we were given by the creditor. This is what the consumer wanted. So
it might not be a sophisticated solution, but can you just, can you ask the consumer? Or, when they put their, fill out their information, is there just a checkbox? Is it, this is not a work email address or something like that? Would that be sufficient?
I think that's a good idea. Yeah.
Yeah.
So.
Something to talk to the creditors about. Again, I'd be concerned just about, for consumers who don't have email addresses, which are the ones that are most financially impacted. So They'll just check the box that it's not anyway. But it's not a bad practice to add to the terms and conditions that they confirm that this is not, So anybody who's listening to the phone call, reach out to your creditors, update the terms of service. That's a great strategy.
So that raised a question that came in. So you should not use a found email for a customer, something you find, I guess, just lying around somewhere or you find online.
Well, I wouldn't, because that gets to the question of what, you have consent to begin with if you're just finding an email address. I mean, you're expecting that if somebody's going to give you consent, they're going to give you the consent that, they're going to tell you where they're going to want to be emailed to. So.
Okay.
Yes, I'm always leery of found, anything found, because it usually should go into the lost and found. So, and again, I think it comes back to what Joe was talking about at the beginning. It's like, you're not just gonna blast, 10,000 emails or text messages. Ramp up your program, test and see what works. You should see a certain percentage that are always going to opt out, kind of like we do from phone calls. Never answer the phone call. We'll have all of those data points. So start slow, start testing this stuff, and pick a good creditor to do it with. One that's got good terms and conditions, one who's got a revocation program if you've got that. Think about all of those things as you start to ramp into these new areas. Just don't go hog wild.
Okay. Some other questions and comments here. Our good friend Larry Lasky sent an email saying that the commentary for the rule makes it clear that the reason the CFPB did not impose numerical limits on text messages was a lack of evidence that it was being abused, and the overall rule v. harassment provided adequate for now protection. So thanks, Larry, for sending that. Some other questions that have come in here. If a consumer opts out of a text message, should that be applied to phone calls using that same number too? Another good question.
I hadn't thought about that.
Or I thought opt-outs were channel specific, according to the terms of the rule, but I'm not.
I mean,
I'm not a lawyer, so.
It seems to me that that you wouldn't be prohibited from calling that number if they opted out with respect to a text to that number. I didn't see anything in the rule that specifically says that once that text comes in, you're forbidden from using any information connected with it. What do you think, Tim?
No, I would agree with that. I think, especially if they respond back with stop, if that's pretty clear. Because you get that in every text you sign up with now. They give you the hit reply, hit help, the standard that always comes that the CTIA or the CITA or whatever they are puts out as a standard response. And so stop would be very clear to me that you want text messaging to stop. I don't interpret, John Bedard did a webinar with Mike Gibb, or it could have been a podcast on this specific subject. The stop doesn't mean cease and desist. Stop means stop texting. So that would be my argument. And Joe, if you were my attorney, I would feel confident with that argument. Somebody's going to make that argument that they hit stop, and that meant cease and desist. Yeah. And so we're going to have to be prepared for that. It's going to be a risk, but I'm confident we could win on that one.
Since the rule came out, and since I've started doing webinars on this topic, a question I get almost every time is, should we wait? Should we implement these now? What kind of issues are there, or are we facing if we choose to put these rules into effect now, or is it better to wait until November 30th when they go into effect? With respect to email and text messaging, how would each of you respond to that question?
I'll take first screen.
Go ahead, Tim. Yeah,
because you can text message now, consumers. You can email consumers now, right? The FDCPA allows you to communicate about a debt with the consumer through any medium. That's pretty broad. And so if you feel the need and you've got consent and you've got the right client with the right information, I think there's an opportunity for you to use text messaging and use email to help communicate with consumers more effectively. And I wouldn't want to wait. I wouldn't want to wait till November 30th. for, texting or trying to find ways to communicate with consumers. We need to do it today. Right party contacts are still, not good. Shaken and stir, my martini mix is having an impact. All of those things are impacting our businesses. So we need to get in touch with the consumers so they know what their rights are, and they know how to communicate with this, how they can resolve their obligations. And so I would say don't wait as it relates to email and text messaging. Joe?
I would say I agree, but don't dive in. As I said earlier, go into this slowly and start with responding to emails rather than trying to do a reach out to grab as many email addresses as possible and then start communicating that way. I think just take it easy. Go into this thing slowly. But yeah, be geared up so that when the deadline comes, you think you've got a system that's in compliance and you feel comfortable following it.
Something else to consider with respect to the limits on text messaging, the ability to specify what medium through which you want to be communicated might be a reason why they didn't impose a limit on the number of text messages that can be sent. Something else to sort of keep in the back of your mind.
Great point.
Other than, aside from the should we do this now question, the other question I get a lot is, how does this apply to first party creditors versus third party agencies? Maybe, we can spend the last couple of minutes sort of talking about that aspect of the rule and to whom it applies. Regardless, it's not just with respect to text messaging and email, obviously, it's the entire rule, but it is a common question that I've been fielding and would like to put to both of you to see if you have any advice you'd be willing to share.
So what exactly was it? I will make sure I understand the question.
That's okay. Third party, like who does, if I'm a lender, if I'm a first party collector, or if I'm a third party collector, how does the rule apply to those sort of different types of collection operations?
Tim, you want to start out?
Yeah, I mean, I think the CFPB's original intention was to cover first party, and then they quickly backed away from that because of all the issues that come up with first party. And I think Harvey asked this question slightly different. It says, how's the impact? How is this new rule impacting, the banking industry, the creditors, and all that other stuff? And so I think that's probably a better way to approach that, is that with call caps, we're not going to be able to do what we've always done. So that's going to, if you're only calling and right party contacts are dropping, that's going to have a liquidation impact on business. And so that's going to directly impact the banks because they're not going to be able to get the money back that they're used to getting back, and there's an expectation, especially that we've set over time. So these rules are going to have an impact on banking creditors, whether they directly apply or not. And so I think the real thing to be thinking about if you're in the creditor first party space is, potentially under a new administration, what if we had these exact same rules for first party? What if we didn't have sort of that stop that we saw, a few years ago about carving out the first party side? And now all of these kind of rules are worse applied to first party. Because I think we've seen a lot of creditors saying, well, we'll bypass these third party restrictions by just becoming a first party. You're white labeling, calling in the name of the, of the original creditor. And so I think if anything that we should be thinking about, creditors should be thinking about is, okay, this is a good indication of what's coming. Maybe it's more of the canary in the coal mine, if you will. So Joe, thoughts there?
Yeah, no, I totally agree. In fact, I was working on a piece for credit reporting agencies this morning about what the CFPB is going to look like under the new director, Chopra. And I think it is going to be very aggressive. I expect that we're going to see all sorts of new rules coming out and efforts to expand the scope of the CFPB to exactly what you're saying. Basically, to take rules like these and apply them, expand them to first parties to make it so that people, creditors can't, they basically are going to be bound by the same types of rules that collection agencies are, which actually may be a good thing for the industry, because it's a little bit of an unfair advantage for somebody to be able, as you put it, white label and set up a collection shop to collect their own debts, and then use systems and procedures that would otherwise violate the FDCPA in doing so.
Yeah, and there's always this possibility. It's one of the last questions that in there is that everything we're talking about today could change. So that is a possibility. I think, Mike, maybe you should set up a legal betting pool where we could take run some odds, because I think, who knows? I think the rule did a pretty good job. It didn't go too far one way or another way. So they'd be hard pressed to maybe throw the baby out with the bathwater, but you never know. You never know. 4 years is a long time.
Sure. Well, unfortunately, we've run out of time. So Joe, Tim, thank you so much for sharing your perspective and your insights with us today. On behalf of everyone watching and listening, I really appreciate it. Thank you very much.
Thank you.
One last time, I want to thank TCN for sponsoring this webinar. Please go to www.tcn.com to learn more about the company. Thanks everybody who listened and watched and submitted your questions. Stay tuned to accountsrecovery.net. We've got news and more webinars coming up tomorrow and all through next week and beyond. So sign up for those if you haven't already, and check out what the site has to offer. And as always, I hope everyone enjoys the rest of their day. We'll talk to you soon. Take care.
Thank you.